Hi, good evening, everyone. My name is Tosin Falaiye, and this is Topmarké's Instagram series. Basically, our way of communicating with our community and getting essential information out there for users to use for several legal issues. As you must have seen the flyers for this event, if you're following our social media handles or several other means of getting this information out there, this session basically seeks to examine the question, in light of COVID-19, is justice on lockdown? Basically considering dispute resolution options that folks may have in Ontario, dealing with their issues during this period. I'd just like to state here that, like I said at the beginning, this is an information session, as it were. We do not intend to create any special relationship here. We're not giving legal advice. We're just trying to ensure that people understand or we push and contribute to getting information out there that people can use in dealing with the issues that are important at this time. So basically, just to start and get right into the issue, access to justice, they say, is an integral part of social engineering. I'm sure folks may say that sounds, it's a high sounding statement. So in breaking that down, as human beings, we interact with each other on a daily basis. And sometimes in our interactions, disagreements are bound to occur. What do we do when disagreements happen? If for some reason or the other somebody slaps you, what do you do? Do you have to slap back? Or for some reason or the other somebody is supposed to pay you certain amounts of money and the person defaults in making those payments? Who do you go to? Sometimes we all need that person we can look up to, or that authority figure that can basically apply the laws of the society to ensure that people can exist or coexist in an amicable manner. So that said, in normal climes where we did not have the pandemic, it was very easy for people to say, you know what? I have an issue with you. Rather than take laws into my own hand, I'm going to see you in court. I'm going to sue you. I'm going to claim damages. I'm going to get an injunction, or whatever the case may be. What do we then do now that COVID-19 has happened? The pandemic started, I believe, sometime in November, kicked in Canada towards the end of January. And, people were listening to the news, and eventually public health policies had to be put in place to safeguard the integrity of our healthcare system and the community generally. We now have the new normal that is called social or physical distancing. People have to stay apart from each other. I have siblings. I can't go to their homes. Our kids cannot have play dates anymore. This is the new normal, essentially. So the question is, how do we navigate when disputes do arise, or disputes arise in the new normal that we have to deal with? The government of Ontario, as well as the government of Canada, has been taking several measures to ensure that the public space is safe. Remember, I said a few minutes ago that in the normal time, it was easy for people to say, I'll see you in court. Everyone has an opportunity to access the corridors of justice as it were. But the government recognizes that places like the courts are public places where people converge and could be a catalyst for the transmission or the spread of the virus. And we do not want that. So in light of this, the government of Ontario declared, I believe sometime in March 17, a state of emergency in the province, basically encouraging people to, as much as possible where necessary, maintain physical and social distancing. I do recall that the Attorney General of Ontario, who is responsible for administering the court systems here, did make the following made a statement around that time, and I'm just going to read something that he did say. The health and well-being of Ontarians is our government's number one priority. This commitment extends across the vast network of justice partners and individuals who interact with the justice system on a daily basis. Put simply, I believe what the Attorney General was driving at here is that, like I said, the courts are a place where people go to seek succor. People access this place on a day-to-day basis. People gather there. And so rather than have a place where the virus can be incubated and passed along in the community, we'll try to keep people away from that. And so the bottom line in that statement and the decision that was made is that the civil courts in Ontario and the courts generally were basically put on suspension in terms of the regular court operations. This was done until further notice. For example, the Superior Court of Justice had its normal operations suspended. The Small Claims Court, which provides a less formal avenue for people to resolve disputes that are not high value, as it were, was also its operations were also suspended. Sittings were suspended until further notice. However, regardless of the fact that the government has asked us to stay away from each other physically, as human beings, we love to interact with ourselves. We love to, people will say human beings are social animals, and we found alternative ways to keep the conversation going, to ensure that the fact that I cannot see you in person doesn't mean that I can't talk to you, doesn't mean that we can't have issues sorted out and things like that. I do remember personally in the period where several countries have had to deal with various degrees of lockdown and all of that, I, as a person, have found more time to interact with my sisters, my siblings. We've had Friday hangouts, game nights, and stuff like that. Those are things that we could not do in the regular, should I call it the regular system or the system that we used to have before. But with social or technology, we've taken advantage of these things like Zoom, things like Skype, things like Microsoft Teams, to ensure that we are able to spend time, even though we're spending that time physically apart. So what that means basically is, as human beings continue to interact, physical distancing or not, there will still be disputes. And as those disputes are bound to happen, it's also important that people have opportunities and avenues to either air their grievances and find resolution to those issues. It's also important to bear in mind that regardless of the fact that state of emergency policies were put in place, there are several activities that people plan to have during this period that have been affected as well. What do people do? How do you seek a redress? What measures can you take? So foreseeable disputes that a person or people could have, regardless of the state of emergency that has been declared, particularly in Ontario, would include breach of contract. I had this time-sensitive trip. For example, I planned a trip sometime in April, and I bought my tickets in December. I was looking forward to that trip. I had a contract with the airline to get me to a particular destination, but because of what has happened now, I can't do that anymore. How do we resolve those sort of issues? I planned my wedding, for example, and I'm not saying I planned my wedding anyway, but just putting that as an hypothetical example. For folks who had weddings planned, how do they deal with their vendors? Vendors who had been paid deposits, do you get a refund of your deposit? How do you find a middle point to say, you know what? This wedding can't happen because the government says we can't gather in numbers exceeding 5, numbers exceeding 3. I believe the number has been changed to 10 now. What do we do? How do we navigate this issue? Or, for example, I'd signed a contract to have a new home delivered to me in 2020, say May. And in March, construction workers could no longer go to the site to complete essential or to complete the terms of that contract. How do we resolve that dispute that has arisen because of what is going on around the world? Or for the folks who may have been, say, for example, laid off from the job and there is no regular income, how does your landlord feel about that? Where you're unable to pay your rent as at when due. Those are issues that are foreseeable disputes that could arise regardless of the fact that people are told to physically stay apart. We're dealing with a public health crisis as well. I need services that are public health related. How do the nurses at the hospital treat me, or I'm a healthcare worker, I'm exposed to risk. How is my employer handling those sort of issues? All of these issues are foreseeable disputes that require some means of resolving those issues. What is important basically is that several issues could arise out of human interaction, and this makes access to justice or a medium of resolving our disputes very essential. So with that background in mind, the question then is, as far as Ontario is concerned, is justice on lockdown? Or is justice gone out of the window? Has justice been locked up in the room, physically distancing itself from the people who usually come to it for resolution? So we would explore For starters, the court system that are publicly available in civil disputes for people to basically have their disputes resolved. What do we do? What is the operative system right now? What is the court open to? What matters are not being attended to in the court system as we know it? So I've written down here that as far as civil rights and obligations are concerned in Ontario, the various courts, either at the federal level or the provincial level, have basically issued new guidelines, what is known in legal parlance as practice directions, to aid the access to justice in a manner that adapts to the evolving situation. Essentially, regardless of what is happening around the world and in Ontario, the government and the public recognizes that access to justice is important. And so while regular operations have been suspended, people cannot physically go into the public courthouses. The operations are still being run remotely. One familiar phrase that has become, like, should I call it a common lingo during this period is WFH, working from home. Court officers technically are working from home as well. And I do recall that when a state of emergency was declared in Ontario, the premier was saying, you know what, even though a state of emergency is declared, this is not a lockdown. Strictly speaking, although eventually the government appealed to people to, as much as possible, work from home, and then eventually close down what was known as non-essential businesses. So in that sense, a major downside to the fact that regular operations are no longer happening in terms of the court system in Ontario is the fact that litigation generally takes a long time. I know of people who wait for trial dates for months and in some cases years. I do recall that sometime last year it was a news item that hearing dates or trial dates were not being set up until 2 years from 2019, for example, and the court system in the Greater Toronto area is fully booked. So in that sort of situation where in the regular world, litigation takes a long time, the new normal that we have only means that resolving your dispute through the public court system will only take a longer time. But as we say in our community, with every disappointment, there is a blessing. There are some benefits that are bound in the new system and the adaptive system that the court structure is taking at the moment. One measure that I think will be beneficial because of what's going on is the fact that while the court is adapting to using technological systems, when things do return to normal, one can expect that the justice system may be able to move along faster because we're no longer dealing with justice based on in-person hearings alone. Things are now being done virtually. So that's one benefit that could possibly arise, that, okay, yes, litigation takes a long time in normal world, but with virtual hearings being put in place, things can move faster along. So things basically move faster and in a more efficient system, more efficient manner, rather. So I'm going to talk briefly about what is known as the Superior Court of Justice in Ontario. The Superior Court of Justice basically is a court that has civil jurisdiction. It does have criminal jurisdiction, but since we're dealing with civil issues here, basically civil issues mean dispute between individuals in the society. The Superior Court of Justice has that jurisdiction to deal with original issues like a court of first instance and even appellate matters. So where a decision is made and parties do not agree with, the Superior Court of Justice has jurisdiction to deal with those things on an appellate basis. And so for this court, regardless of the fact that normal operations have been suspended, urgent matters are still being attended to by the court. And the question is, what is an urgent matter? The court has defined urgent matters in this case to include public health issues, matters where financial repercussions, significant and financial repercussions may happen where the court doesn't attend to it. So, for example, a person needs a preemptive relief, or should I call it a protective measure in terms of an injunction. The court is open to attending to those issues regardless of the fact that its physical doors are closed to the public in that sense. So these hearings are to be done in writing where the situation allows for that. There's also the possibility of tele and video conferencing. And in this situation, what people did in the normal system is take your documents to court and file them at the registry. Now, filing can be done by electronic means, and it has been put in place to limit paper submissions as much as possible. So I believe an email has been dedicated to this, where parties with urgent and sensitive matters can have their documents sent to the court and attended to by the judge. It's also important to note here, even for folks who may not have legal representative, many clients or many people with disputes self-represent. And in such a situation where a person is having difficulty navigating or understanding the rules that have been put in place, Ontario has what is called Pro Bono Ontario, where self-represented litigants can reach out to lawyers or people with understanding of how the system works to explain and break these things down in an understandable manner. And so once you put in your documents electronically, a judge assesses the situation and determines whether or not this is something that an urgent hearing is merited for. And in that situation, you are able to serve your documents by electronic means to the other side. The other side gets an opportunity to respond, and a hearing is done in that sort of situation, like I said, by tele and video conferencing. Ultimately, the court recognizes the fact that the rules of court as it is today were not done with a pandemic in mind. And so while practice directions have been put in place, we understand that the practice direction may not cater to all situations. And so because of that, as the need arises, there is some flexibility that the court can use in applying the practice direction and doing justice depending on the situation that it is faced with. So to maintain the public nature of court proceedings, and what that means basically is, like I said, the court is a public arena where everybody is welcome, and as much as possible, the court tries to do justice in the eye of the public. So regardless of the fact that the doors are closed at the moment and we're dealing with issues in a virtual manner, it is very possible for members of the public to participate or observe proceedings that are being done virtually or by teleconference. Information about matters that are being scheduled by the court is available on the court's website, and folks can follow up. People in the media, pressmen can always follow up and indicate an interest in participating in that proceedings, and the court will allow you observe such proceedings. But it's also important to bear in mind that this is an evolving situation, and I do believe that to a large extent the curve has been, what's that phrase? To flatten the curve, right? The curve has been brought down to a large extent, and the court system is rebooting, in my opinion, or in my own phrase. Beginning in by July 6th, which is a couple of days from now, in-person hearings are going to commence for certain matters, and in those situations, litigants will be contacted and informed of the schedule of the court. But ultimately, jury trials, for example, are not expected to start anytime earlier than September 2020. In setting up all these adaptive measures, the court has also taken the position that litigants are expected to comply with procedural rules or procedural orders as much as possible, regardless of the fact that normal operations have been suspended. So you're encouraged to file that process you're supposed to file within the time you're supposed to file it in using the virtual resources that are available to you. For parties who are unable for some reason or the other because of COVID-19 to comply with procedural steps, you would have to explain to the court why you are unable to do that when operations return to normal. Ultimately, the Superior Court of Justice in Ontario has proactively adapted to the evolving situation to maintain justice despite the pandemic. But what you will find here is that even though urgent matters have been attended to, this is not at a cost this is being done at a cost to matters that are not considered urgent. So for the non-urgent matters, those things are not being attended to. So again, comes down to issues about what options you have if you want your matter to move forward regardless of the lockdown or suspension of regular operations that the court system is dealing with in Ontario. I mentioned the small claims court earlier as well. This is basically a branch of the Superior Court of Justice. I keep saying the Supreme Court, but I'm talking about the Superior Court of Justice that deals with civil actions where the monetary claim is up to $35,000 in a less formal manner, basically ensuring that there is a cost-effective, faster approach for people to resolve their disputes. And just like the Superior Court of Justice, the operations of the small claims court has been suspended till further notice, but urgent matters are being attended to. Garnishment hearings are being done remotely. Time-sensitive matters that will result in immediate and serious financial hardship, where a hearing is not done, are being attended to as well. Again, evolving situation. As of June 2020, settlement conferences at the small claim courts for non-urgent matters is now possible where parties agree. So basically, the party who has come to court with a complaint and the party who is defending that claim can both agree based on the pleadings to move forward with settlement conference. If, like I said, if they agree to that. The small claims court also has an electronic or virtual means of transmitting documents to the court. So plaintiff is allowed to send in or make your claim using the court's online filing system. For a defendant, you're able to mail in your documents to the court either by registered mail or either by courier, as the case may be. But ultimately, as things get better in the community, the court is expected to resume regular operations in the weeks ahead. Finally, in terms of the provincial courts in Ontario, I will talk briefly about the Ontario Court of Justice. This court, in terms of civil jurisdiction, deals with a number of family law-related issues. You could file your claims online, and your defense could also be mailed into the court. Resumption of regular operations is expected to happen in the weeks ahead. In-person hearings would happen from July the 6th, as the Attorney General is taking efforts to put measures in place to keep the safety of the public as the courts make efforts to reopen. So unless matters are urgent, new applications are not being heard, and a resumption announcement will be made in the coming days. So we've talked briefly about the provincial court system for civil disputes. We're going to talk about federal issues that have to do with Canada-wide, should I call it Canada-wide jurisdiction, or jurisdiction that the federal government of Canada has control over. Things like intellectual property, maritime and admiralty law, and in some cases, or not in some cases, Aboriginal law generally. In some of these issues, the federal court doesn't have exclusive jurisdiction, so things could run either on a provincial basis or at the federal court. For the federal court as well, operations have been suspended, but for Western Canada, things have picked up. For Ontario, this is expected to the suspension period is expected to last up until July 25th, and so as things get better, the court is expected to come back in place. The timelines for procedural steps in generally immigration-related issues have been suspended, but for statutes and other legislative instruments that are outside the purview of immigration and, say, judicial review matters, the timeline will continue to run. And so where you're unable to fulfill your obligation to take a step in a proceeding, you can always seek for extension of time and explain to the court why you're unable to comply. Just like the provincial courts, the federal court is also dealing with urgent matters where financial repercussions would arise, where steps are not taken. Say, for example, seizure of ships, aircraft, or other properties. These things the federal court will consider to be urgent. So if your matter relates to such issues, you may be able to proceed regardless of the lockdown. And for the federal court, it already did have a system where electronic filing was possible, whereby you can use virtual resources to get your documents across the court. This, regardless of the lockdown, is still operational, and people with disputes that are within federal jurisdiction can always send in their documents that way. Now, for Ontario, like I said, the suspension period is expected to end July 29th, but hearings will not happen or sort of adjourned indefinitely. Hearings that are scheduled between March 16th and July 25th have been adjourned indefinitely. But ultimately, in Ontario, the timeline for you to take procedural steps will commence, I believe, sometime July 13th. And just to note here, the federal court a couple of days ago did have its first virtual trial. So this just puts in mind the fact that regardless of the lockdown, justice and access to it is very important. I'm looking at the picture that is posted on the federal court's Twitter page, whereby it had the judge, had the court registrar, counsel for both parties, the witnesses, the court reporter. Everybody is right up on this picture that was posted on the federal court's Twitter page. So virtual resources have made it possible for the wheels of justice to move forward regardless of the pandemic. Having talked about the federal and the provincial court system as it is right now, you'll find that a recurring issue across the court system in Canada is a commitment to serving justice regardless of the impediments that have been posed by the pandemic. Thankfully, some tools that facilitate the virtual court system have been put in place before the state of emergency was declared, but clearly the courts have adjusted quickly to ensure that adverse consequences of a lockdown in terms of justice is mitigated. So the court has basically tried to ensure that even though we cannot physically welcome you, we're still serving justice, which is an important element of keeping human relations in peace. What is also clear is that the evolving and adaptive nature of things in certain cases means that there will be longer than usual delays for people to have their matters resolved through the public court system. What that then says to me is, while I cannot be sure that my matter will be heard anytime soon through the public court system, what options do I have outside of the court system to have my disputes resolved? And that's where we talk about alternative dispute resolution, which the court itself has encouraged. You will see that if you take a look at the court's website, it's contained in most practice notices that parties are encouraged to seek alternative means outside of the court to resolving their issues. And the fact that you have a case that is already pending in court does not mean that you cannot explore alternative means to resolve your dispute. And so some options that you could have is exploring one, negotiation, mediation, arbitration. There's something called a collaborative process, which we will talk about shortly, as well as the hybrid ADR process. So I'm going to start with negotiation as an alternative means of dispute resolution. Negotiation basically is a party-driven process whereby I'm a wedding planner. I already had a contract to deliver goods and services on a particular day to a couple getting married, but because of COVID-19, that cannot happen. Rather than us get to drag ourselves out, we go sit down to say, Mr. Vendor, you're a photographer. You're supposed to take photos at my wedding. I've paid you some deposits. Let's talk this thing over. I do not see the possibility of this wedding happening in a couple of months. Can this service still be possible when things resume to normal? Or is there some compromise we can come to in ensuring that a dispute does not drag along? Party-driven resolution of issues that arise is what is known as negotiation. To find a compromise rather than sticking to your guns and saying that it must be my way or the highway. Parties are encouraged to sit down and find a middle point to move things forward. And negotiation can be used in a variety of issues: contractual disputes, employment issues. Ultimately, it comes down to the will of the parties to find a middle ground to resolve their issues. Ultimately, when an agreement is reached between these parties through negotiation, you can then put it in writing to say, this is our understanding, this is the grounds we have shifted upon, and this is how we are going to move forward to relate together in peace. What is important, though, is that what agreements people come to by negotiation, by the negotiation technique, can be enforced in court ultimately. So that's one way you can save yourself the trouble of waiting till the court system resumes to have your issues resolved. Now, mediation. Mediation basically is a confidential process in which parties meet with an accredited mediator or a professional mediator to assist in resolving the disputes between the parties. So basically, just keeping this in a scenario sense, I have a dispute with Mr. B, and we get a professional mediator. We sit down in the room. The professional mediator sees, okay, what does Mr. B think about this issue? What do I think about this issue? And that mediator tries to lead conversation along the lines of resolution. So that professional mediator ensures that parties are able to possibly see things from a different lens. When a person takes a look at your own perspective alone, you may not be able to understand the perspective of the other party. That's what a professional mediator essentially does, to get you to think about the dispute in a different sense that would aid resolution of the dispute. And the good part of mediation is that virtual technology is useful for mediation proceedings. Zoom, Microsoft Teams. Zoom, for example, has breakout rooms whereby the mediator can move from talking to you, where the both of you can hear what is being talked about, to talking to one party independently. And you often find that, in my experience, for example, where the mediator has a one-on-one in-person session with individual parties to a dispute, you may get to see and test their pulse and find out things that they are not disclosing in the general meeting that may aid resolving the dispute at hand. So mediation is an option that folks with disputes in Ontario can consider to resolving their disputes through the pandemic. Now, collaborative process. This is a system that is being, should I say, advocated or advanced, or is useful or being used in the family law setting. But I do think that it is something that can also be used even in non-family law related dispute. Basically, it entails seeking dispute resolution by a team effort involving the parties, legal representatives, and neutral professionals. So basically, in the arena of family law disputes, a family law professional facilitates discussions around communication and parenting issues that the parties or the couple may have, while a financial professional gathers information about the financial health of each party and tries to advise them in terms of what financial decisions will impact their future in terms of going their separate ways or dealing with children in the marriage and all of that. This sort of system, I believe, is useful even in non-family law related issues, where you can get professionals that are should I call them subject matter experts, that may be able to say, okay, you know what, dealing with this construction issue, here's what the custom of the trade is. This is one way you can come to a resolution, and parties relying on a team effort can collaboratively come to a middle ground to find a resolution to their dispute. Ultimately, when agreement is reached through a collaborative process, it is put down in writing and can ultimately be put forward as a consent issue for the courts to basically enforce. Another alternative option to the court system is, I'll call it like a pseudo court system, but it's known technically as arbitration. It involves a professional arbitrator that is appointed to examine the disputes between the parties. It could be one arbitrator, three arbitrators, or depending on the agreement of the parties, they could determine the number of arbitrators they need to resolve their issues. You'll find that many contracts these days have alternative dispute resolution clauses, arbitration clauses, but ultimately, for situations where such clauses were not included in the agreement, nothing prevents the parties, when a dispute arises, to agree to go into any of these alternative dispute resolution options. Arbitration in Ontario is regulated by the Arbitration Act, and there is also the International Commercial Arbitration Act that basically adopts what is called the model law in arbitration to determine the, should I call it, the procedural issues and all of that goes into an arbitration. But ultimately, it is less formal to the court system and usually goes faster than the court, provided the parties cooperate to facilitating that process. I'd mentioned that it's a less formal approach. The final outcome of an arbitration proceeding is that the arbitrator, different from a mediation session where the mediator talks you towards settlement, the arbitrator is meant to make a decision which will be binding on both parties. So parties who are locked in a dispute at this point in time, without knowledge of when their matters may move forward through the court system, may want to speak with their lawyers or consider between themselves coming to an agreement about an arbitration agreement and resolving their disputes through that means as well. Finally, I will talk about what is called the hybrid ADR option, which basically deals with a combination of two ADR mechanisms. For example, mediation and arbitration put together. So if parties agree that, you know what, before we get to the point of arbitration, we would explore the possibility of mediating this dispute. We would appoint a mediator who possibly could also act as an arbitrator. That mediator sits the parties down and tries to talk them into settlement. Ultimately, if that process doesn't pan out as the parties expect, they can then transition with that same mediator into an arbitration setting. So the mediator who had talked the parties possibly into settlement can then move forward to say, okay, now we're in arbitration setting. I've listened to your evidence. I've listened to the other party's evidence. And ultimately, this is a decision I think should be made in resolving the disputes that you have. In conclusion, social distancing and physical distancing is a thing. But ADR options are easily adaptable to the various virtual tools of communication in today's world, and parties can take advantage of these tools while our public health authorities figure out the best way to have our court system up and running again and keep all of us safe while getting the wheels of justice moving again at its regular pace, or possibly even faster than it was before the pandemic, given the fact that the courts now have embraced virtual dispute resolution, as it were. Ultimately, I do believe that the answer to whether or not justice is on lockdown would depend on the parties to the dispute. So it's up to you as a party who has a dispute to resolve to determine how fast you want to go, how adaptable you are to technology in our changing world, and ensuring that rather than go through the adversarial system that litigation really is, you may want to consider using ADR mechanisms while possibly also preserving your right to have your disputes resolved through the court system. So that's basically it in terms of whether or not justice is on lockdown and the options you have through the pandemic to resolve your disputes in Ontario. So I'm just going to go right here to the comments I've seen so far and see how we can answer questions. So this person is asking, are you angry with your neighbor for making noise, but not sure what to do since you can't take him to court because of lockdown? Well, I don't think it's a case where you can't initiate proceedings like we said. There are electronic means by which proceedings can be initiated, but ultimately you want to consider the fact that a person is your neighbor and you can always talk these things over. And so in terms of dealing with it in a formal manner, you could have a letter written on your behalf, basically letting the neighbor know what your issues are and proposing measures by which a resolution can be reached. But ultimately, if that doesn't work out, there are several measures that you can take to have such issues resolved. It will also there's also the part of considering what sort of neighborhood is it that you're dealing with. If you're in a condominium, for example, I do believe that the condominium corporation may have internal measures by which such issues can be resolved. So you may want to talk to your condo management for such issues and see what options you have before ultimately going down the road of resolving via litigation. Which option do I know is best for me in terms of the dispute resolution options? I think that it would depend on the issues that you have at hand. Like I said at the end of my presentation, a party may want to still keep their leg in litigation at the court system while exploring this option. So ultimately, a litigation is more expensive in terms of cost that it will take you to go through the court system. If you're also considering the cost, you may want to put as priority alternative dispute resolution as your means to resolve the dispute. But I think that the issue you're dealing with, the specific issue you're dealing with, determine what is best for you. In certain cases, like say family law disputes, getting a divorce ultimately would have to be a declaration by the courts. So you may want to put your leg there while also dealing with separation agreement issues through alternative dispute resolution, maintenance issues through alternative dispute resolution, when you know that ultimately the order to dissolve your marriage has to be made by the court system. Okay, so I have a question here about the difference between negotiation and mediation. Like I said, negotiation essentially is a party-driven process. Mr. A and Mr. B have a dispute. They want to talk it over between themselves. They could possibly have their lawyers in the meeting, but they are the ones who determine, okay, you know what, this is the issues that we have. We have identified the issues. Here are propositions we are making. Rather than have you pay me 100,000 in the month of May, can we split the 100,000 over 5 or 6 months, and you pay me in tranches? That is parties talking over the dispute and saying it's not really worth the while to go through the formal process. I can shift on this ground. What can you shift upon? And they come to an understanding in resolving that dispute. But in terms of mediation deals with a professional mediator that talks the parties. Rather than have the parties talk by themselves or talk out the issues by themselves, the mediator identifies, you know what, these are the issues in this dispute. Have you considered thinking about it this way? Have you considered taking these steps? How would you feel about getting your payment in, say, 5 months? How would you feel about, rather than having your tenant, for example, pay you rent every month at the beginning of the month, how would you feel about delaying payment till the end of the month to get your rent paid, rather than having to, say, go to the landlord and tenant board or deal with processes of evicting a tenant? I also think it's important to mention here, and I just remember this, that Ontario has taken protective measures in terms of issues around residential tenancies. Eviction notices, an injunction was issued by the Superior Court of Justice to prevent eviction processes while the state of emergency is in place. There's also the issue about statute of limitation. Basically, this has to deal with statutory limitations on when you can bring an action to resolve a dispute. So say for just a hypothetical example, in issues about libel, somebody has defamed your character in a written publication. There is a limitation of about 3 months that you must decide whether or not you want to have this dispute resolved by the court system. In certain situations, there's a limit of 2 years from the time you were aware of the dispute for you to initiate the process to have issues resolved. What Ontario has done in terms of that is to say that during the period of emergency, the statute of limitation legislations that exist would no longer run or will be suspended. So that saves you the trouble. In the event that you're unable to take essential steps during this period, you won't be prevented from exercising your right to seek redress when things return to normal. So I just thought it's important to point that out. But basically, I mentioned the difference between negotiation and mediation. Okay, so I just addressed, I think I addressed this before. In terms of comparing the court system and alternative dispute resolution, I would say that alternative dispute resolution is considerably lower cost compared to the court's system, as it were. So if parties are negotiating by themselves, there's probably a limit to the cost that they will incur. Possibly at the end of that negotiation, they get a lawyer to codify or draft the terms of settlement for them. They incur that cost. They don't have to incur filing costs and things like that. In terms of an arbitration, parties have to consider paying the arbitrator, looking for a venue, paying your lawyers, possibly getting expert witnesses. So that may bring your costs possibly closer to what you would incur going through the court system. But I think that parties may be able to mitigate on this cost to make the process affordable for them. So ultimately depends on which of the ADR options you are going for that will determine the cost. But generally speaking, ADR is more cost effective provided if the parties cooperate with the process. Okay, so this is like a follow-on question to the issue about the noise and evidence. You know what, if a person is going to resolve an issue, it will ultimately come down to evidence. So you have to consciously make an attempt to observe. If you need to record the noise you're hearing, video recordings and things like that. You also need to take note of when you made reports or try to talk to the neighbor about resolving the issues. Ultimately, if you have to go down some option of dispute resolution, it will come down to what evidence you have to back up your position for you to get a decision in your favor. So for a person who is wrongfully dismissed from the workplace and resorting to alternative dispute resolution, my take on that is that many organizations have internal mechanisms for resolving such wrongfully dismissed or no. Okay, so you're already dismissed. In that sense, I do believe there probably is an administrative body for dealing with labor and employment issues, but this is not something I'm really sure about. So I would say that I'll just refrain from that in terms of speaking emphatically about alternative dispute resolution and wrongful dismissal. But I do think that if both parties to the dispute agree to go through, say, mediation and arbitration, it is something that can be explored between the parties. But for you to participate, you really can't force the other party. In terms of litigation, you can force the other party to come to court, but you can't force the other party to participate in an ADR measure that they haven't agreed to. So if your employment agreement does have an ADR clause, that may be something to hold on to. But if the parties see that, you know what, because of the lockdown or the state of emergency in the province, rather than wait for the court to determine or adjudicate on these issues, let's explore those things. Parties have to agree to explore those options. So I do think that in a general sense, we have gone through most of the questions that are in my comment section here. So in the absence of further questions, we will bring in this session to a close. I do hope that the information that we have shared in this brief time together, you will find it useful to see that where, because of the state of emergency, things are not moving as fast as you expect or want for it to go, you can seek an alternative means of resolving your dispute. It's also important to know that there really is no downside to it at the moment for the emergency period if you're unable to initiate your action. Why that is so is because the period of limitation has more or less been suspended pending the return to normalcy in the community. It's also important to note that regardless of the fact that the court system is closed at the moment to members of the public, it is operating remotely through virtual means. And if you have an urgent issue that requires resolution, you need an injunction, there's some financial repercussion that will happen if you do not get that injunction. You can always put forward your case to the court for the court to consider whether or not it is urgent. If you have public health issues or pending, should I call it, judgment debts for which an arrest warrant has been issued, these are some of the issues that are considered urgent during this time, and you may be able to push forward through the court system during the state of emergency in Ontario. Ultimately, it's important that while you're dealing with your dispute, you get professional guidance. So if you're trying to go the road alone, I talked about Pro Bono Ontario, where you as a self-represented litigant can seek guidance for the technicalities that you may not be familiar with, or ultimately you want to consider retaining a legal professional to hold your hands through the process. That said, I would like to thank you all for coming to our Instagram live session today. We do hope that you found value in the information provided. We have several other sessions that are lined up through Instagram and other, should I call it, virtual technologies for communication, Zoom and all of that, that will be coming up as time goes on. We also do have a YouTube page where several sessions that we have had over the course of the state of emergency in Ontario are posted. You may want to do yourself some favor to go there and see what information may be useful to you. If you also seek further inquiries about some of the things we talked about, you can always reach out to us via our email. It's info@tpmattorneys.com. We do have our offices in Toronto. When things resume to normal, our offices will be open, and ultimately our goal is doing what we can to help our community and the folks that rely on our services. Thank you once again for coming out this evening, and I do wish you a happy Canada Day in advance. Thank you. Good evening.